Thank you, Jessica, and welcome to, let's make sure we got this right, Washington. You're from Washington and you are Unit 2, and it's 1 o'clock Eastern time, right?
Correct.
And we're in the right Zoom room. Quality control has been met. My name is Trey Delap, and I am a couple things. I'm a We the People alum. I competed in 1996 at Nationals, and it was a thrilling experience. So in context, I can very much appreciate how hard you have worked for this, and I am so glad that you and your teacher were willing to do this extraordinary experience. I mean, this is first time ever anyway. So I'm excited. I'm really excited to see what you guys have going for you. Once these tech kinks are over, it's a normal hearing. That's how it feels. So it's going to be completely normal. So whatever happened to you before is going to happen again. But I do want to applaud you for this, and you are the standard setter. You're going to set the standard for today. In addition to being an alum, I'm the executive director of the Nevada Center for Civic Engagement, and we just inherited the We the People programs for the state of Nevada. So that's an exciting new engagement. Other than that, I have a private public affairs firm, and I'm a lobbyist. So that's the other evil side. But I am excited to see what you guys have come up with, and I'll invite my colleagues to introduce themselves.
Well, good morning to you, although it's afternoon on the eastern side. My name is Lynn Uzzell, and I teach American politics at the University of Virginia, and I couldn't be more happy that we're going to go through with this national competition, even with all the challenges that we have. So kudos to you.
Morning. I'm Lindsey Draper. I'm from Milwaukee County, Wisconsin, retired from the juvenile bench in Milwaukee County, still an attorney, and happen to be a Seattle University grad, so have a kind of warm feeling towards Washington.
Excellent. And we can see your names, but is your teacher with you today?
Yes.
Excellent. Well, we wanted to
Hello, I'm Gretchen Wolfing. Pleasure.
Well, we want to thank you too. I know, I don't know, but I have a feeling that you've done some extraordinary work today. So thank you for bringing it. So now, I don't know if this was ever told you, but no one's ever died in a We the People experience. I don't think it's going to happen today, so please don't die today. But, you know, go with it, take some breaths. No one can see below your waist, so, you know, whatever. Moving on. The question we have for Unit 2, how did the framers create the Constitution? Question 1. The states sent delegates to the Philadelphia Convention to join with other states in devising, and quote, devising and discussing all such alterations and further provisions as may be necessary to render the federal Constitution adequate to the exigencies of the Union, end quote. To what extent, if any, did the delegates follow their instructions? What experiences of state governments under their new constitutions after independence might have influenced the creation of the Constitution? Do the decisions of the U.S. Supreme Court function as a continuing constitutional convention? Why or why not? Please begin.
What might be extravagant today might in half a century become penurious and inadequate. Alexander Hamilton.
In 1787, the Confederacy's Congress sent representatives to the Philadelphia Convention for the purpose of revising the Articles of Confederation.
Yet upon arriving in Philadelphia, framers like Hamilton and Madison had already decided to abandon the Articles, which had proven incapable of solving three large federal functions: taxation, amendments, and the executive branch.
After witnessing the inability of Congress under Article 8 of the Articles of Confederation to minimize the national debt, the framers resolved that Congress must have the power to lay and collect taxes through Article 1, Section 8 of the new Constitution.
In addition, framers like Charles Pinckney concluded that the depressed state of the Union was due to the requirement of unanimous consent in order to amend the Articles. Therefore, Article 5 of the Constitution would restructure the amendment process to require only 3/4 of the state's consent.
Historian Richard Beeman blamed the crisis of the Confederation period largely on the lack of an executive, rendering the government incapable of carrying out essential tasks.
With this in mind, the framers designed Article 2 of the Constitution to create energy in the executive, which Alexander Hamilton called in Federalist 70 one of the best distinguishing features of our Constitution.
The Constitution provided a blank slate for the founders to build upon, creating a foundational document that would be able to preserve the crumbling Union.
In creating the Constitution, the framers used experiences of state governments as framework for their decisions. Unlike the Articles of Confederation, the states have been able to evolve with their constituents, illustrating several possible solutions to remedy the state of the Union.
The Philadelphia Convention was sparked by the experience of Massachusetts in 1786, as the violence of Shays' Rebellion drew the framers' attention to the irresolvable debt of the nation, motivating the creation of taxation power within Congress.
In addition, Massachusetts provided the foundation for a new amendment process, as in 1779 the Massachusetts state legislature called for a separate convention of elected citizens to construct a new state constitution.
This concept of enabling an elected assembly disconnected from the state legislature to create constitutional change would be mirrored in Article 5 of the Constitution through diversified amendment process.
Much of Article 2 was modeled after that of the New York Constitution, as State Governor George Clinton aided in resolving debt by redistributing taxes among loyalists, proving the necessity of an executive in order to establish economic stability.
Ultimately, by combining their own experiences with efficient state structures, the framers could create an ideal federal government capable of addressing the exigencies of the nation.
With the framers' intention in mind, the decisions of the Supreme Court cannot act as a constitutional convention, as it is incapable of implementing change in the Constitution and rather serves as a mode of interpreting constitutional text.
As stated by attorney Jonathan F. Mitchell in a Michigan Law Review article, Supreme Court rulings settle disputed constitutional issues, but cannot be treated as part of the Constitution itself.
The idea that interpretation cannot be mistaken for legitimate change is evidenced by the Supreme Court overruling its own decisions over 300 times, undermining the supremacy of the Constitution in Article 6, Section 2.
For example, in 1954, the court reversed its former decision of Plessy v. Ferguson and Brown v. Board of Education, deeming the separate but equal doctrine unconstitutional.
A year later, the Supreme Court was forced to make a second ruling in Brown v. Board of Education 2 due to a lack of efficiency in desegregating schools, demonstrating the court's little authority outside judicial proceedings.
This implies that decisions by the Supreme Court can be deflected by any individual state. As seen in Alabama's creation of the Human Life Protection Act, it ignored the precedent created by Roe v. Wade.
Rather than delegating the power of constitutional change to the Supreme Court,
Please finish your sentence.
the founders chose to rely on Article 5, allowing we the people to revise the Constitution for our own posterity.
Thank you. And now we'll start with some questions. Professor Lynn?
Sorry, I thought you were going first. So my question is about your last point that the Supreme Court cannot be a constitutional convention, and your main reason for that is because the court itself overturns its prior decisions. But I'm wondering, could that not also, that fact be interpreted as being that it is a continuous constitutional convention, that every time they make a decision, that is considered the interpretation of the Constitution until they change it, in which case they change the meaning of the Constitution. So does not that suggest that actually the Supreme Court does act as a sort of constitutional convention?
So we define a constitutional convention as that which changes the literal text of our federal document and the structure of our federal government. In this case, we don't want to argue that the Supreme Court doesn't create societal change in its interpretations of the Constitution. Indeed, the Supreme Court has been capable of immense change over the course of our American history. However, because it doesn't create literal change in the text of our document, which Article 5 of the Constitution does accomplish through the amendment process, we don't consider it a continuing constitutional convention.
Obviously, the fact that we're a couple of centuries into work under the Constitution says that it's where we are. It sounded as though you were indicating because some of the people showed up not intending to do what they got asked to do, this is all pretty illegitimate. Is that what you're saying?
No, we would like to, if we look at original founding documents, such as the Declaration of Independence, for example, we can see with the sentiments of Thomas Jefferson, which reflect John Locke and the ability of the people to overthrow or change their government if they see it as corrupt or notwithstanding. Many of the framers use this sentiment to disobey their directions to simply amend the articles. We can also see with people like James Madison with the Virginia Plan, they had already established new plans, and especially at the Annapolis Convention, which Hamilton and Madison had left from with the intent of creating a new constitution.
This idea of the consent of the governed, which they disobeyed at the Philadelphia Convention, was later put into our own Constitution, Section, the First Amendment, with the right to assemble and right to petition.
Thank you.
Thank you. What I'm most curious about in this question is when people are delegated authority in our system and the circumstances are such that require what would be considered a supererogatory duty. In order, if you told us to go save the Union and you tell us to go up there and revise something, but we realize while we're up there that in order to save the Union, we got to reboot it completely. What authority do you believe those delegates drew from that authorized them to scuttle the articles and create this entirely new system?
Well, to quote
my favorite founding father, Thomas Jefferson, did not attend the actual Philadelphia Convention, but he wrote the entire Declaration of Independence, which was a heavily, not criticized article, but actually heavily interpreted within the convention itself, expressing the natural rights that we as human beings having, that being life, liberty, and happiness. Certain things like this gave these titles and the specific bodies of documents that they saw and interpreted during the convention, the idea that they were more than just simple paper or some sort of human. They kind of have the status, as Thomas Jefferson said, the Philadelphia Convention was a assembly of demigods.
To add on to this point, James Wilson during the Philadelphia Convention actually read the entirety of the Declaration of Independence to put forth the idea that after a long train of abuses and usurpations has occurred, it is the duty of the people to install new government which may provide the best guards for our future security. In this case, cases like Shays' Rebellion in 1786 and the resistance to a certain amendment, such as the Impost Amendment in 1781, had proven that the Articles of Confederation were incapable of protecting the posterity which the founders wanted to provide for.
The framers also took it from the authority of John Locke's social contract, in which John Locke's idea of the social contract is that the people have the right to revolt if they see the government is ruling unjustly.
Additionally, we can see with my own favorite founding father, Benjamin Franklin, one of his most famous quotes is the responsibility of the people to always question authority. In this case, Benjamin Franklin went into the Philadelphia Convention, seeing that the divide between states and the federal government would eventually lead to the topple of our union. And we can see this through Article 8 of the Articles of Confederation, which gave the states individual taxation powers. And this was eventually later established through Article 1, Section 8, Clause 1 with federal taxation power within the Constitution.
All right, let me ask you, because you gave good examples of how the states provided a framework for the federal Constitution. Could you give me examples where the state constitutions were not good examples?
Well, we can see that
I guess not.
these. Oh.
Thank you. Good job.
Yay.
Very good.
Well, thank you. And we'll start with feedback. I'll yield to my colleague, Professor Lynn.
So let me just say that that you set a great model as our first team in this new format. I mean, you guys entered it with a great deal of poise and enthusiasm, and I thought that you had a wonderful opening statement. It was very informative, and you also had a great Q&A. I thought that that you did a good job of fielding our questions. And you also provided some really good historical examples when you were in the Q&A section, and that's always where the rubber meets the road. Although I do question, somebody said that James Wilson read the Declaration of Independence at the Philadelphia Convention, and I know the convention pretty well, and I don't remember that episode. So I'll want to check up on that. But overall, I thought that you guys had really mastered the material. So good job.
So I want to, first off, I need to start by complimenting you on this. This was not easy, you know, because everybody knows that all of you worked somewhere other than together as a unit, and you didn't have the normal preparation activity. So I need to start by complimenting you on that. And just sort of tell you, when I first read this question, I thought this was so far and so wide and so many possibilities that there was no way that in 4 minutes you all were going to answer all three of these pieces of the question. There came a point as you were doing your statement that I realized, wait a second, they're doing the part answering the Supreme Court part. They have addressed everything they need to talk about, at least in their answer to this. So I need to compliment you on that, because I was worried that that wasn't going to happen in the question. Had I gotten the chance to ask another question, and because of how much material here is that wasn't going to happen, I wanted to ask about impact of having, you know, northern states. You know, was there any place that other states had in terms of their constitutions? But I really think you covered the stuff that I wanted to hear. I appreciate it. You did a wonderful job. Thank you.
I want to compliment you as well. I think I wondered how I would feel about this format, and you're the first to go, the first in this new format. And I feel at the end of this first hearing, just like I would if we were in the hearing room. The juices are flowing, and really, I'm very gut checky. And if I leave the people hearing and I feel like I'm chomping at the bit to ask more, then that was good. I really, I agree with my colleagues. You covered everything in the formative speeches, but your answers in the follow-up are really great. And if you hadn't caught my tactic, is I'm always looking for the moral authority. At what point do we have to do something extraordinary when we don't know what to do? And that is certainly what happened. And I think you handled it beautifully. So congratulations, and thank you so much for giving us this opportunity to do this, because it's just so much fun. And I hope your futures are bright and pretty, and you'll get to do it again tomorrow.